The sight and sound of the demolition of a Scottish oil rig. While this decommissioned North Sea rig had reached the end of its useful life, is this a scene we're to see far more often in the years to come? Today marks what some are calling a serious shift for the future of UK energy security. For the past half-decade, campaigners have fought Surrey County Council through the courts against their decision to allow the expansion of an oil well back in 2019. Well, today the Supreme Court has ruled in their favour that planning permission for new fossil fuel extraction cannot be granted without taking into account the use of final oil products far down the chain. In short, construction has to take into account of far more than the environmental impact of the site itself. Until today, the entire industry worked on the assumption that emissions from constructing the wells, rather than the use of the final products, should be considered in their planning assessments. But this landmark case today changes that and has serious implications for the future of oil and gas drilling in the UK. The complainant, Sarah Finch, spoke to the press outside the court and said other energy projects may now fall thanks to this ruling.
It's going to make it a lot harder for anyone to open a new oil or coal, whatever field, and it has implications for some that have already been agreed but are under subject to legal challenges, such as the coal mine in Cumbria, the giant Rosebank oil field in the North Sea, the Jackdaw field, and not forgetting our sister site Biscathorpe in Lincolnshire.
Well, UK Oil and Gas plc have today said they'll now ensure that future production will fall below the levels at which environmental assessment is required, limiting production, limiting revenue, limiting growth. And because the law on environmental assessments is based on EU law, this ruling could have impacts on the wider continent as well. Well, goodness me, let's digest this now with the usual host of this programme, the former Business and Energy Secretary, Sir Jacob Rees-Mogg. Jacob, thank you for joining me and welcome back to your usual time slot. This is a pretty profound ruling today.
It's a very unfortunate ruling. It seems to me to be a very political ruling. It's interesting that the lower courts, the High Court and the Court of Appeal, didn't take this route. They didn't think you should take this into account. And I'm deeply concerned that the Supreme Court is trying to make energy policy rather than simply interpret what planning law is meant to say, and therefore has deviated from what everyone thought the law was before. And this could potentially constrain our ability to use our own resources. It won't reduce global emissions. It will simply mean other countries make the money, not the United Kingdom.
And yet these lawyers have found this ruling and argued this ruling within the words of UK statute, within the Climate Change Act. Is it right to be blaming the lawyers and the courts and the judges? Or rather, should the fault, if it is a fault, or perhaps some people will argue this is a very good thing, isn't it to do with the legislation that MPs have passed?
Well, I think if you look at how this judgment has come about, it's a 3-2 ruling in the Supreme Court. So it's a very narrow margin in the Supreme Court when the Appeal Court and the High Court found in the other direction. I am concerned that you see the courts, and we saw this over the small boats, becoming increasingly political. So this is the Baroness Haleisation of the Supreme Court, and it fascinates me that since she's resumed her seat in the House of Lords, she constantly, when she bothered to turn up to vote, voted against the government. That there is a left-wingery, I fear, that is abroad amongst the judiciary, and this is moving now into the climate area and can potentially make people cold and poor, which seems to me highly undesirable.
It does seem that there are, no doubt, activist lawyers and indeed activists who brought this case to drag it through the legal system. But haven't politicians like yourself given them fertile ground with which to play? Indeed, the Climate Change Act is what this is based upon. And the government, the UK government and Parliament nodded through the net zero commitments in the dying days of Theresa May's administration.
Well, the Climate Change Act was passed when the Labour Party was in office, and I hadn't been elected to Parliament at that point. I think Gordon Brown was Prime Minister at that point, and I wasn't MP. So I can't take the blame for the Climate Change Act, but I think it's really important that we revisit the commitments we've made on the Climate Change Act. Other countries aren't doing this. We're 1% of global emissions, and we are making this nation poorer, trying to achieve something that without other countries doing it simply won't happen. And this judgment is in its way fatuous, because it won't change emissions. It will merely change the ease of us using our own resources. Other countries will still exploit their resources, whilst we'll find it harder to use ours. And I think that's deeply unfortunate. And I think it is a pity that the Supreme Court decided to move away from the earlier and lower courts.
Now, when you were Business and Energy Secretary, did you see many of these issues cross your desk? How involved are the politicians who run these departments in keeping abreast of all of this action? Because it seems whenever anyone tries to, for example, open a new coking coal mine or a new oil well or whatever it is, there is just legal action after legal action after legal action.
That's a very fair point, and I was very keen to ensure that more licences were given in the North Sea, and we worked very carefully to make sure that was done in a way that wasn't subject to legal challenge. There was an incinerator plant that I would have liked to have given approval for, but I wasn't allowed to because of the risk of judicial review, mainly dependent upon the common seal. And the thing about the common seal is it's common, and it wasn't going to be at very great risk. But nonetheless, we have got ourselves in a situation where ministerial discretion is consistently being undermined. And I think ultimately you want democratic, accountable control. Now, you're right to say a lot of the problem with this is in the legislation. And I would be keen to see a change in legislation so that we can exploit our own resources more. We need to ensure the United Kingdom is competitive. That's the way we're going to improve the standard of living, the condition of the British people, that they can be more prosperous.
Well, Sir Jacob Rees-Mogg, thank you so much for returning to this time slot, and it's really, really good to see you.
Always a pleasure.
Thank you very much. Well, with me now in the studio is the campaigner for Defend Our Juries, Tim Crosland. Tim, you've taken some of this action in the past. Why is it that so often activists are using legal avenues rather than political avenues?
Well, because we have the rule of law in this country, and one of the laws that we have is before a major project is undertaken, we make sure we understand what the impact is going to be. We make sure we understand what the impact is going to be on those Surrey residents whose homes have been flooded this year, on the Surrey farmers whose crops have been destroyed this year by flooding. That is the law, and when you're digging up oil, it makes sense to understand the impacts of burning that oil. That is the only thing the Supreme Court has judged today, that to pretend when you're drilling for oil, the burning of that oil is irrelevant, would be a fantasy. It would be to undermine democracy. It would be to deliberately blind ourselves and bury our heads in the sand.
This is what was argued in front of the Supreme Court justices. It was a split decision.
It was 3-2.
So some of those justices said that actually the burning of this oil, does that have a direct impact on the residents of Surrey? Does it really? I mean, the amount of oil that would have ever came out of this well, it's immaterial to the amount of climate change that's going on.
Well, if it was immaterial, why didn't they assess it? They didn't assess it.
Because the industry standard was to assess the impact of the project, the construction of the project, rather than any end state down the chain effect of burning oil or doing whatever it is with your making plastic with the oil, whatever it is. That had never been thought to be assessed. And it does seem to some people that what happens here is that activists decide they don't want this to happen, and then line by line go through to find any chink in the armour of these impact assessments that are hundreds, sometimes thousands of pages long. I mean, it does look like it's lawfare.
I think that's a very cynical perspective. I think there's a much more democratic perspective on this, which is before major corporations with vast resources behind them and vast propaganda teams and PR firms before they undertake a project that we think is likely to have impacts on the resources we all depend on, our land, our air, our water, our crops. We understand what the impact is going to be. And those lobbyists and those lawyers, I mean, just imagine who's got the bigger teams of lawyers here. Is it the Exxons and the BPs, or is it the tiny little activist groups?
Well,
those lawyers
activist groups are fairly well funded these days.
Not compared to big oil, believe me, not compared to big oil. And so it's those lawyers who have worked to get us into a very counterintuitive position where we don't assess the impacts of burning the oil, which is the whole point of drilling for the oil.
Now, of course, you've worked for the government in the past. You have been there at COP26 and been part of that drive to get more clean energy delivered. Are you not worried that exactly the same tactics that are being used now against oil and gas are also being used by some green campaigners against solar farms, against wind farms, and against nuclear power? Three things that are vital in the energy transition. There are currently green campaigners who are using environmental impact assessments in much the same way that they were used in this case to stop new offshore wind farms because they might damage fish and they might damage birds. Are you not worried you've opened a Pandora's box here?
I think understanding the implications of what we do has got to be a good thing for democracy.
At the cost of clean green energy?
Whether apply this same principle to green energy, it's understanding the impacts of the wind farm, understanding the impacts of the nuclear energy, and assuming we can live with those impacts, the project proceeds. Applying that principle to those other cases.
These projects now come with thousands of pages of regulation, of red tape, of green impact assessments. Spain has, in the last couple of years, decided to do away with the same intense level of environmental impact assessments for green projects. Why does it make sense to have this level for green projects, that they must meet the same sort of environmental impact assessment requirements? This is lawfare, this is red tape, and it's tying up our own domestic energy production.
Well, this only kicks in where a project is likely to have a significant impact on the environment. If it doesn't, and the judgment is it isn't going to have that impact, then it shouldn't face this kind of procedure. But that's what the Supreme Court has said today. The only thing we're discussing here is the Supreme Court saying, let's stop pretending that the point of this drilling of oil isn't to burn the oil. And if the point is to burn the oil, let's look at what the consequences of that's going to be for the residents of Surrey, who only this year have had their homes flooded, their farms flooded. Surrey County Council just earlier this year put out a call to residents of Surrey saying, we have £5,000 compensation for your funding.
They might well want some of the 75% windfall tax revenue on oil and gas to perhaps build some flood defences.